Hi everyone, welcome to the eMoney experience. We're going to talk about safeguarding again. The previous session was in relation to the FCA's new consultation on safeguarding requirements, new safeguarding requirements for eMoney and payments firms. And this session will follow on from that. It's also about safeguarding, but it's a bit more specific. So we're going to focus on this new requirement to establish, to maintain, to put together a resolution pack. So just a quick kind of recap of last time. So the FCA's new safeguarding proposals are that we are going to have some interim rules, and then by the point at which the FCA have successfully secured their outcome of the PSRs and EMRs being repealed and all requirements therefore being put into the FCA handbook, we will then morph into the end state rules. So in the meantime, whilst the normal safeguarding regime from the EMRs and PSRs still apply, the interim rules are some new rules. So we're going to be carrying out some more record keeping and reconciliations. These may be somewhat similar to the guidance that already exists in the AD in relation to this requirement. There will also be enhanced monitoring and reporting. There's this new requirement whereby we will have to carry out an annual audit of compliance with safeguarding requirements. So we'll have to find or engage a safeguarding auditor on an annual basis to carry out that compliance audit. And there is a requirement for eMoney and payment firms to submit a new safeguarding return on a monthly basis to the FCA. So new reporting requirements, new audit requirements, new monthly reporting requirements in these new interim rules. And then everything that's kind of in the interim rules will carry over to the end state rules. So we'll kind of build up and everything will come together at the end in the end state rules when everything appears in the FCA handbook. Interim rules, we've still got strengthening elements of the safeguarding regime. So this is in relation to carrying out due diligence on existing safeguarding providers, getting those acknowledgement letters, the template letter that's in the annex to the AD, getting our safeguarding providers to furnish those letters to us, so we have that acknowledgement. And then the end state rules, what the FCA, I was about to say PSR, what the FCA are aiming for in the end is that safeguarded funds will be held on statutory trust in favor of the clients who will be the beneficiaries. And other aspects of the safeguarding regime will also be strengthened, such as payment flows changing. At the minute, we can receive funds into an operational account or some other kind of business account, as long as we safeguard those funds by the end of the following business day. By way of recapping the earlier session that we already kind of went over this, but one of the main impacts will be that in the end state rules, funds are required to be received directly into the safeguarding account upon receipt. There are some exceptions, but generally speaking, that will be the rule. Receiving funds not into an operational account, segregating and then safeguarding by the end of the following business day, but receiving relevant funds from clients directly into the safeguarding account and safeguarding from that moment. Last time we discussed the cost to firms. This is the cost benefit analysis. We already went over this. So I will go right into the CASS resolution pack. So this is one of the interim state requirements to establish this resolution pack. and then it will also carry over into the end state requirement. So this will be an ongoing requirement to have a resolution pack. So what is the CASS, Client Asset Source Book? In the FCA handbook is what CASS means. It's a source book, Client Asset Source Book. Currently, EMIs and PIs are not within scope of CASS, and the statutory instrument that the draft that the FCA has published in draft form at the end of the consultation purports to bring EMIs and PIs in scope of CASS as part of the interim state and end state rules. So the purpose of the CASS resolution pack is to ensure that a safeguarding institution maintains and is able to retrieve information that would, in the event of its insolvency, assist an insolvency practitioner in achieving a timely return of relevant funds held by the safeguarding institution to its clients, and in the event of a firm's resolution, assist the Bank of England or FSCS, and in either case, assist the FCA. So the purpose of the CASS resolution pack is that if there is a resolution or ultimately an insolvency, it contains all of the information that the insolvency practitioner would need to return those funds to the clients. It is, I guess, somewhat of an instruction manual. When the insolvency practitioner is appointed, the insolvency practitioner walks into the firm to run the firm, everyone else has walked out, and then the insolvency practitioner can use this pack as a manual, instructions, relevant information in order to secure the return of those relevant funds to the e-money holders and payment service users. So that's the purpose of the resolution pack, able to retrieve the information. So this is the main obligation. So all of these requirements are from the draft statutory instrument published by the FCA at the back of the consultation paper 2420. It has a draft statutory instrument it sets out the interim state rules, and then it goes into the end state rules. It's pretty long. What else can I say about it? It has amendments to not only CASS, but also SOP. But we'll go through these rules now, and I think by the end of the session, we'll have quite a hold on this obligation to maintain the resolution pack. It'll be fine. So what is the main obligation under the draft CASS rules? So a safeguarding institution must maintain and be able to retrieve, in the manner described in this chapter, a CASS resolution pack. So that's the overall obligation, maintain and able to retrieve. Please note that the draft rules published by the FCA use this term safeguarding institution. And this means the firm or the EMI or PI that is required to safeguard customer funds. It doesn't mean the safeguarding bank. It means us as the EMI or PI subject to the safeguarding obligations. So the terminology here, don't worry, don't be confused. Safeguarding institution, meaning the EMI or PI subject to the safeguarding obligations. So there's our obligation. We have to maintain and then be able to retrieve it. We have to have it and then be able to find the pack. Group application. So can we have a whole resolution pack can we have one pack for the whole group? So before launching into the contents of the pack, the draft rules say, for the purpose of this chapter, a safeguarding institution, us, will be treated as satisfying a rule in this chapter, requiring it to include a document in its CASS resolution pack if a member of that safeguarding institutions group includes that document in its own CASS resolution pack, provided that group member is subject to the same rule and the safeguarding institution is still able to comply with that other rule, don't worry. So the group member is subject to the same rule. So in theory, yes, we can have a CASS resolution pack that applies to different parts of the group. However, the group members, both have to be subject to FCA rules. So that kind of affects its efficacy, really, because it would only be applicable if we had a group member also authorized by the FCA. So if we have a parent in the US or a parent in the EU, they, generally speaking, are probably, unless something else is happening, they wouldn't be subject to FCA rules and would not be subject to a rule in this chapter. So we would really have to have all of the documents and all of our own CASS resolution pack at firm level held with us rather than elsewhere. And then there's this kind of narrow exception that if we have a another part for a firm or an EMI or PI authorized by the FCA in the UK, then I guess we could have a CASS resolution pack held with that firm as well. However, it seems to be less effective. Okay, CASS resolution pack time limits. So in relation to each document in the CASS resolution pack, a safeguarding institution must put in place adequate arrangements to ensure that an administrator, receiver, trustee, liquidator, appointed in respect of anyone able to retrieve each document as soon as practicable and in any event within 48 hours of that officer's appointment. So within 48 hours of the insolvency practitioner being appointed, they have to be able to locate the resolution pack, and that's the same. Ensure that it is able to retrieve each document as soon as practicable, 48 hours, where it has taken a decision to do so or as a result of an FCA or Bank of England request. So insolvency practitioner appointed or a request from FCA or Bank of England, 48 hours, thus have to locate the resolution pack. So it should be to hand, and documents probably should be collated together for ease of reference. So what parts, before we get into the core substantive documents that should be contained in the resolution pack, what documents should be immediately retrievable? So for the purposes of that requirement to have the resolution pack, the following documents and records should be retrievable immediately. A, the document identifying the institutions referred to in CASS da-da-da and CASS da-da-da. So this is the document identifying the our safeguarding bank or banks. Or, I mean, I'm going to focus on safeguarding banks here and putting funds in a safeguarding account rather than by insurance or guarantee method. So that's essentially the document identifying the institution providing the safeguarding services. So generally speaking, the safeguarding banks. B, the acknowledgement letters. So this is the acknowledgement letters from the safeguarding banks that we've procured from them. And they've said that they've established safeguarding accounts for us, and the funds held in those accounts are held, they're relevant funds held for customers. And there is a template in the draft requirements for that acknowledgement letter. A copy of each policy or guarantee. So indeed, if we safeguard by way of insurance or guarantee, then we have some of the documents that have to be retrievable immediately are the policy or the guarantee, the insurance policy or the guarantee. The insolvency practitioner will need to read the terms of those. D, the document identifying individuals pursuant to CASS 10.2, blah, blah. So this is the document identifying the senior managers that are critical to safeguarding operations. So this is the list of individuals who have who are responsible for safeguarding operations, who have access to safeguarding accounts, who are perhaps senior managers of the firm, senior members of the finance team, for example, involved in reconciliations, for example. And then E, the most recent internal safeguarding reconciliations and external safeguarding reconciliation records. So we should have our most recent reconciliation records to hand immediately. So these 5 documents, we're meant to have them. So whilst the time limit that we just discussed, the insolvency practitioner is appointed, or the FCA or Bank of England requests the insolvency pack, and then we have, pursuant to the time limit that we just discussed, the actual rule is 48 hours, meant to furnish these documents within 48 hours from that moment. But then there's this additional provision that sets out these 5 documents that we just discussed, the list of safeguarding banks, the acknowledgement letters, the insurance or guarantee, etc. This provision is not a rule, it's an evidential provision. So it's not legally binding as such, it's not a rule and it's not guidance, but you'll see there at the bottom, it says CASS 10A 1.9E, E for evidence or evidential. And this is evidence of compliance. So if these 5 documents are retrievable immediately, if they're to hand immediately, and they don't take 48 hours to locate pursuant to the earlier time limit, then that's evidence of compliance with the time limits. That's what E means in the context of the FCA handbook. We have R for rule, G for guidance, obviously, and then E, evidential provision, evidence of good compliance with the rules above it, essentially. Then there's this requirement to update the CASS resolution pack. So a safeguarding institution must ensure that it reviews the content of its CASS resolution pack on an ongoing basis to ensure that it remains accurate. So an ongoing requirement to review the content of the resolution pack in relation to any change of circumstances that has the effect of rendering inaccurate a material aspect, in any material respect, the content of the documents, must ensure that any inaccuracy is corrected promptly, and in any event, no more than 5 business days after the change of circumstances arose. And an example of a change in circumstance that would need to be promptly corrected is, for example, a change to the safeguarding bank. If we decided to safeguard our funds with a different bank, that would have to be quickly updated in the CASS resolution pack. So constantly updated. No inaccuracies. And then there's just some other requirements before we launch into the substantive components of the pack. So a safeguarding institution must ensure that its governing body receives a report in respect of compliance with the rules in this chapter at least annually. So there's an annual reporting requirement to the board. And then a safeguarding institution must notify the FCA in writing immediately if it has not complied with or is unable to comply with CASS, which is the main obligation to maintain the pack. So if you if you somehow realize that your firm hasn't maintained a PAC and is otherwise unable to locate a PAC, then the requirement is to notify the FCA in writing immediately. Okay, core contents of the PAC. There are 10 main documents plus reconciliation records. This is an overview table. We'll go through each of them. 10 main documents and some records. So let's get into it. I mean, why not? All right, first, a safeguarding institution must include within its CASS resolution pack, first, a master document containing information sufficient to retrieve each document in the institution's CASS resolution pack. So a master document, kind of a how to locate where is everything. I'm the insolvency practitioner. Where can I locate everything? What are my instructions? A master document, essentially. Second, a document which identifies the institution, the safeguarding institution has appointed for the receipt or holding of relevant funds and for the holding of relevant assets in accordance with CASS. So this is one of the documents that we discussed before, that if we are able to furnish this immediately or retrieve this immediately, then that is evidence of good compliance with the rules. So this is the document. You identify the institutions that we've appointed to hold relevant funds, the document that identifies our safeguarding banks, our safeguarding providers, safeguarding service providers. 3, for each institution identified in 2, so that's as we just discussed, each institution identified in 2 is our safeguarding partners, our safeguarding banks. A copy of each executed agreement, including any side letters or other agreements used to clarify or modify the terms of the executed agreement between that institution and the safeguarding institution that relates to the holding of relevant funds or assets, including any acknowledgement letters sent or received pursuant to CASS 1510. So we have a master document. We have a document identifying the safeguarding service providers, the safeguarding banks, our safeguarding partners. And now we have the contract with the safeguarding bank. And if there's any kind of we need the whole agreement. We can't just have the initial agreement if it's been updated or a side letter or something over time. We need the entire agreement. So yeah, third requirement, contract with the safeguarding bank. And acknowledgement letters, apparently. 4. So this is in relation to firms that safeguard by way of insurance or guarantee. I said that we wouldn't focus on this, but nevertheless, in the interest of completeness. So 4, it's kind of the same requirements as we just discussed for the safeguarding bank, but a document which identifies the institutions the safeguarding institution has appointed to provide insurance or a guarantee in accordance with CASS. For each institution identified in 4, a copy of each executed policy or guarantee, including any side letters or other agreements used to clarify or modify the terms of the executed policy or guarantee. So similarly, we've identified the provider and we've provided the core document upon which the terms of the relationship are documented. Policy, guarantee, contract, it's kind of the same requirement, just repeated in a different context or for a different type of safeguarding option. 6, a document which identifies each agent or e-money distributor of the safeguarding institution. So relevant to those EMIs and PIs that engage payment service agents or deploy a network of e-money distributors. 7, a document which identifies each, a document which A, identifies each member of the safeguarding institutions group involved in operational functions relating to the safeguarding obligations imposed on the institution under CASS 15. Okay, so here, identifies each member of the safeguarding institutions group involved in the operational functions relating to the safeguarding obligations. So this is where we've engaged another member of our group who is involved in operational functions relating to safeguarding. For example, we might outsource aspects of financial reconciliation. There might be other senior managers with access to the safeguarding account, and they are from a different group within the institution. So we have to identify each member of the group that's involved in operational functions that affect our safeguarding obligations. And you'll note that the words electronic money regulations and payment services regulations are crossed out. So in the interim state rules, they're not crossed out because the obligations imposed on the institution to safeguard customer funds are indeed under the electronic money regulations and the payment services regulations. But under the end state rules, when, as discussed before, when the FCA secure their kind of ultimate objective of having the PSRs and EMRs repealed and all rules contained within the FCA handbook, everything, all of the obligations in relation to safeguarding are intended to be in CASS. So that's why, so in the first section of the draft statutory instruments in the consultation paper, we have the interim state rules which say about, well, they mention the EMRs and PSRs, but then they're removed in the draft statutory instrument that sets out the end state rules. Just in case you're reading it and that doesn't make sense. And then B, for each group member identified, the type of entity, such as branch, subsidiary or nominee company, the group member, its jurisdiction of incorporation, if applicable, and a description of its related operational functions. So a UK company may, for example, outsource safeguarding operational functions to an SA company incorporated in Luxembourg, and then a description, some of the finance team responsible for reconciliations, reporting, are located in Luxembourg, just as an example. So just identifying another member of the corporate group that's involved in operational functions relating to safeguarding. It may not be applicable to your firm. Safeguarding operations might be entirely contained within your UK entity, and this wouldn't be applicable. This is for firms who are part of a group structure. Further, more core content. So 8, a document which identifies each third party which the safeguarding institution uses for the performance of operational functions related to any of the safeguarding obligations imposed on the institution. B, describes how to gain access to the relevant information held by that third party. And C, describes how to effect a transfer of any relevant funds or relevant assets held by the safeguarding institution but controlled by that third party. So this is kind of similar to the earlier requirement, whereby we have to have a document that identifies anyone else who is involved in the operational functions relating to safeguarding operations. So if anyone else is involved, whether they're a group company or it's outsourced to a third party, then we have to have a document explaining who this party is, whether it's a group or whether it's a third party, and how the insolvency practitioner can gain access to this relevant information held by the third party, and So you can see there's more, because this third party is external to the group, there are more requirements. So how instructing or describing to the insolvency practitioner, if the insolvency practitioner has to approach this third party to gain access, who are they? How do they gain access? Where is the relevant information? How to effect a transfer of funds that is controlled by the third party. So all the information that the insolvency practitioner would need, whether those operations are deployed by the firm itself, a group company related to the firm, or a third party, or outsourced to a third party. 9, a copy of the safeguarding institution's procedures for the management, recording, and transfer of the relevant funds and relevant assets that it holds. So a copy of our safeguarding procedures. And then 10, a document which identifies each senior manager and director and any other individual and nature of their responsibility within the safeguarding institution who is critical or important to the performance of operational functions related to any of the safeguarding obligations imposed on the institution by CASS 15, the individual to whom responsibility for CASS operational oversight has been allocated under CASS 1522R. So here we have, again, for the insolvency, so you can always view it from the perspective of the insolvency practitioner, because they're not familiar with the individual people who work within the firm and their functions. So when they come in and they are tasked with returning client relevant funds to clients, client money to clients, they're going to have to know kind of who is involved, who is critical and important to these operational functions relating to safeguarding. This will be, authorized managers, heads of finance, accountants, EMD individuals, PSD individuals. And then also there's this new role, the individual to whom responsibility for CASS operational oversight has been allocated. So there is this new role. It's kind of like, there's a new role, right? So firms, EMIs, and PIs have to allocate responsibility for CASS operational oversight to someone within the firm, an individual within the firm. It's kind of like the consumer duty champion, isn't it? It's a requirement for a specific role. Certainly, similarly, kind of moving towards the senior manager's certification regime for EMIs and PIs, slowly moving towards those individual carved out roles with specific responsibilities. So the insolvency practitioner will need to know who that person is, because they'll probably need to talk to them in order to operationalize to deploy the insolvency process. So that's a list of the core contents that have to form the CASS resolution pack. And then finally, after these 10 documents, there is a requirement. So a safeguarding institution must include, as applicable, within its CASS resolution pack, the records required under CASS 15.6 appointment of a third party to manage relevant assets, selection and appointment of a third party, policies and procedures, records and accounts, more records and accounts, and customer contracts. So there's some other kind of documents required outside the core contents: policies and procedures, records, reconciliations. These will be updated from time to time. Reconciliation records, of course, constantly updated. And then finally, just casting our mind back to the earlier session where we discussed the cost-benefit analysis published by the FCA in the context of this consultation paper. We discussed the resolution pack. And in the cost benefit analysis, the FCA estimated that the cost to the firm with respect to the requirements relating to the resolution pack was £680. And this was a once-off cost. It wasn't kind of an ongoing cost, which appears inconsistent with the requirement, the rule that we discussed earlier, to constantly check for inaccuracies and ensure that any inaccuracies are remedied and updated, and the pack updated to be accurate within 5 business days. So that seems kind of incongruous that there will just be a once-off cost. But just to kind of cast our minds back, so the rationale basis that we discussed previously was that the FCA considered that it would take one kind of mid-level compliance professional 2 days to collate the pack, and then one senior compliance officer 3 hours to check. Having discussed the core contents of the CASS resolution pack, it may be worth considering, would it perhaps take slightly more than one person 2 days and another person 3 hours to put this pack together? I would, seriously consider allocating perhaps more resource than £680 to these rules. They're not short. They're detailed. They're timely. There are time limits. They're very serious. There's a requirement to notify the FCA in the event of non-compliance. You remember there was a rule that if it transpires that the firm hasn't actually maintained a CASS resolution pack or is unable to find it, then there's a requirement to notify the FCA immediately in writing. So given the kind of severity of that notification requirement, firms may wish to kind of read the rules themselves and consider what the extent of resource they wish to dedicate to establishing their own pack, and perhaps not be guided by this, because it does not seem extensive enough, considering the nature of the requirements. All right, thanks team. Thanks very much. I'll see you at the next session. Well, this won't be the last time we discuss safeguarding. We will revisit it soon. All right, thanks.